I welcome you to the e-lecture series organized by the Seminar Subcommittee of the Colombo Law Society. I'm Vijay Gamage. I'm the president of the Colombo Law Society. Colombo Law Society, which was started in 1975, presently has a membership of around 4,000, and it is the largest branch association of the Bar Association of Sri Lanka as well. We at Colombo Law Society are committed to make a strong and an independent bar. This e-lecture is the sixth of the series organized by the Seminar Subcommittee, and past e-lectures have been very successful and the participation has been really encouraging. Today's topic is going to be on a very practical value, just like the earlier topics, and it's going to be delivered by a much respected practitioner and who is a past president of our society as well. I would like to thank the organizers of this event, co-chairs of the Seminar Subcommittee, Mr. Chathura Galhena and Mr. Sanath Karunaratna, then our treasurer, Mr. Nalin Samarkon, and the organizer, Mr. Imal Simitiyas. I would like to especially thank Chathura, Mr. Chathura Galhena and Imal for organizing today's event. And we will be conducting this e-lecture series on every Friday evening, and I invite you all to join with us next week as well. Now, I invite our moderator, Mr. Chathura Galhena, to introduce today's speaker. Thank you.
Good afternoon, ladies and gentlemen. Generally, before introducing the speaker, I used to obtain a CV of the speaker during past 5 webinars. But today, of course, I never asked from Mr. Nawaratna what to be said about him, because he is very well known to every corners of the legal fraternity. He was the secretary of the Bar Association who has won the elections with the largest majority in the history. So, of course, I don't think anyone needs any further explanations about Mr. Nawaratna. But I must necessarily mention his relationship with the Colombo Law Society. He has been our one-time past secretary and one-time past president, who has been with us throughout. And with a very short notice, he agreed to deliver today's lecture. And what he wanted is just the time and what the topic that we want to discuss. And today's topic, of course, Mr. Nawaratna is having a very vast experience over this topic that he's going to talk today, because he's a practitioner in the district court and also practitioner in the civil appellate courts, other like civil appellate high court, court of appeal, and the Supreme Court, where injunctions and stay orders is a day-to-day activity that happens. Nawaratna is very qualified to talk about this topic, and his practice is spanning, I think, over 25 years now. And we can't actually, in the second generation, he's one of the leading counsels who dominate the bar. I would say the second generation, because there is a generation above Mr. Nawaratna's generation in the legal profession. But in our generation, he's one of the pioneers or the forefront, in the front liners in the profession. So without taking much time, I would invite Mr. Nawaratna to talk about today's topic. And today's topic will be on the injunctive reliefs. We will be emphasizing also on the Parate execution procedure. It's over to you, Mr.
Nawaratna. Thank you, Chathura. And thank you, Mr. President Vijay Gamage, two of my good friends. And I'm overwhelmed by the kind words expressed by the President as well as my good friend Chathura. Good evening, ladies and gentlemen. Thank you, Chathura and Mr. President, for inviting me to share some thoughts on a much important topic in the civil field. And I must say few words about the good deeds that are being done by the Colombo Law Society in the recent past. And it is our it is a much debated topic, since of late there had been many criticism that had been leveled against the practitioners, especially the youngsters in the legal profession, and the lack of knowledge, lack of application to the professional day-to-day duties has been discussed at many forums. It is in this context various steps were taken by the Colombo Law Society, as well as we are aware, by the Bar Association as well. And the contribution from the Colombo Law Society has been immense in the past, and we are looking forward that they will contribute much more than before for the betterment of the legal profession in future, especially under the leadership of our present president, Mr. Vijay Gamage, that is amply demonstrated by the prompt action taken by Mr. Vijay Gamage in the recent past, especially when we were having many obstacles because of the lockdown, the COVID issue. Therefore, without going for much discussion on those lines, whilst thanking to the Colombo Law Society once again for inviting me to discuss certain aspects relating to the law relating to the grant of interim injunctions. And I will deal with mainly, rather than going through the complex legal provisions, I would like to discuss or rather share some thoughts on the area of practical aspects, ladies and gentlemen. Therefore, firstly, let me discuss what do you mean by an injunction. What is an injunction? So, and every practitioner, but mainly the people who are participating today in this webinar, I'm sure that they are the attorneys, but it's I'm told that there are many junior practitioners, so therefore it is important for the juniors to know what do you mean by an injunction. What is an order relating to an injunction? So that is important before going into the nitty-gritties of the injunctions or the law related to injunctions. And you must know what you mean by an injunction. Injunction is an order issued by court in order to prevent a person from committing a civil act, not a criminal act. That's very important to know. Or a civil act, or commanding someone to undo some wrong or an injury. So that is, if you take it on a very plain and simple meaning of an injunction. Injunction, as I said, is an order issued by court to prevent a person from committing a civil act, or commanding someone to undo some wrong or an injury. So now there are two aspects of it. So when you take an injunction, you can obtain an injunction either to prevent a person or to restrain a person from committing an act or a civil act. If it is a criminal act, certainly, and we are aware, it's need not go into much details. You can't prevent a person from committing a civil act by granting an injunction. So there is a separate procedure, separate law is applicable. So therefore, that you have to invoke the jurisdiction of other forums that to prevent that act being performed. And then there is another, the second aspect of it, the commanding someone to undo some wrong or an injury. So if the act has already been performed, sorry, you can obtain an injunction to undo a thing or an act what has been already been performed. That is important to know. Now, for instance, if someone has erected an obstruction or created some obstruction or a roadway whereby a person has been completely prevented from having access to his house, let's say, for the purpose of argument, then you can seek, rather than otherwise, normally the substantive reliefs are granted at the conclusion of the eventual trial. So if an obstruction has been created or a building is being constructed right across a roadway, can you wait until the final conclusion of the case? No, you can't. In that circumstances, you are entitled to compel that person to undo the wrong thing what has been done. So therefore, on principle, injunction can be obtained for actionable wrongs. Number one, firstly, to prevent a person from committing an act. If the act which can be undone without going through many obstacles, then the injunction can be obtained to get the act what has already been performed undone. So that's that areas has to be carefully looked into. But of course, I must say, each and every application related to injunctions is dependent on the facts and circumstances of each and every single case, because each and every single case has its peculiar the facts and circumstances. Therefore, the law has to be applied carefully to fall in line with the facts and circumstances of each and every single case. So, ladies and gentlemen, so we have to the second aspect we will deal with the legal provisions in a short while. But what has, one must remember at what stage firstly we know that about what do you mean by an injunction, what is an injunction now, and then at what stage that you are entitled to make an application for an order or to obtain an injunction. And there are two aspects that has to be looked at. Firstly, if it is a new action, at the time of the institution of the action, you can make an application for an interim injunction. We will deal with the law related to the procedural law in a short while. Then, during a pendency of the action, if the application for the interim order has not been made at the time of the institution of the action, then the party who's aggrieved by an act performed by the opposite party, then he is entitled to make an application to obtain an interim order, interim injunction, pending the action. So then two aspects we covered. The thirdly, this is very important to know, ladies and gentlemen, because we have seen people make very serious mistakes when making application for interim relief. And can you file an action only to obtain interim orders? That is very important to know. That is something which even some people, they make mistakes without having substantive relief. They file actions. Some people have instituted actions just to obtain an intervening order and for an interim injunction. Can you do that? So I will deal with the law, but the simple answer that you cannot file an action just to obtain interim relief, but without having an application or a relief for some substantive relief from court. So normally, as we are aware, the injunctions are granted until the final conclusion of the case. So the basic principle that is applicable, just to maintain the status quo, the injunction is granted. Why? So that is something which we as practitioners must pay attention, especially when we advise our clients. Because the injunction is not granted, your rights will be severely affected. So if clients comes and say that someone is trying to enter into a land, of course, there I must say that in terms of the principle enunciated in the Pounds versus Ganegama case, it's a very renowned case as far as the injunction law related to injunctions are concerned, where it has been held under the guise of interim relief, no one can eject a person. So that is another area that has to be borne in mind when you are making an application, especially if someone is trying to use your land or jump into a land, some that encroachment, then you have to couch the relief in such a way where the court will not rely on the principle of Pounds versus Ganegama, because it's a very basic principle where it has been held that no party will be ejected under the guise of interim relief. So that is another aspect that you have to bear in mind when you decide or rather advise clients relating to injunctions. Sorry. Then, ladies and gentlemen, another important thing now, as we are aware, injunctions are normally granted until the final conclusion of the case, until the final hearing and the determination of the case. So the procedure, when we discuss the procedural law, we'll go into the main nitty-gritties. Then until that interim injunction is granted, normally we know in the district courts or the commercial high courts, an inquiry is held. So the no injunction will be granted ex parte without the other party being heard. So we will deal with the case laws in a short while. So therefore, upfront, you are not entitled to obtain an interim injunction. So there will be an inquiry relating to that application. So firstly, what you are entitled is an enjoining order. The normally court will issue an enjoining order valid for a period of 14 days. So then the what has to be established for you to obtain an enjoining order pending the hearing and the determination of an application for an interim injunction. You have to substantiate with sufficient evidence that in the event if the enjoining order is not granted, that the rights or your client's rights will be severely affected. And further, you have to substantiate that even afterwards, if the enjoining order is not granted, that if the judgment is entered in your favor, and if the act is performed, what is sought to be restrained is performed pending the hearing and determination of the application for an interim injunction, that your rights will be violated, infringed, and ineffectual. So therefore, that ladies and gentlemen, these are little basic principles that has to be borne in mind when an application for injunctions are made. We discussed what do you mean by an injunction, then at what stage that you can make an application for an interim injunction, and can you file and can you make an application only to obtain interim injunction. So that now we are aware that you can't do that because of the principle relating to the grant of interim injunction. So so when you those are the basics related to injunctions. Now we have to know under what law that you have to make an application, and as to how an application for interim order can be made. So basically, when you analyze the law relating to grant of injunctions, there are two aspects of law that has to be discussed. Firstly, the substantive law. Secondly, the procedural law. Where do you find the substantive law? Because it is well settled law. The procedural law is also as important as the substantive law. So you can't simply ignore the procedure that has to be adopted when you make an application, or when you have to make an application for interim relief. So it's especially interim injunction. So when you say the substantive law, ladies and gentlemen, as of today, the law what is applicable, or rather the power that has been conferred on courts, or the jurisdiction what has been conferred on courts, is found in section 54 of the Judicature Act. So if someone wants to properly make an application, you have to have a better understanding of section 54, which empowers the district courts, the high court, and the family court to grant an injunction, and the circumstances under which the parties are entitled to invoke the jurisdiction of court to relating to injunctions. So that sets out the substantive law. And substantively, how you put into practice? You put the substantive law into practice with the procedural law. Where do you find the procedural law? So always remember this procedural law and the substantive law are complementary. They are admixed. You can't separate them. If you violate the procedural law, then you can't make the proper application. If you don't comply the substantive law, it is needless to state the application cannot be maintained. So therefore, you have to have a better understanding how the substantive law can be put into practice by complying with the procedural law, and the procedural law is found in the Civil Procedure Code under Chapter 48. Chapter 48 of the Civil Procedure Code is extremely important if you make an application for interim injunction. So in Chapter 48, there are a few sections that has to be carefully studied, ladies and gentlemen. You must read section 662 to 667 of the Civil Procedure Code, which sets out the basic procedure as to how an application for interim injunction could be made. If I may just take you through the section 662, this is what it says. It says every application for an injunction for any of the purposes mentioned in section 54 of the Judicature Act. You can see the procedural law connects with the substantive law, that is in terms of section 662, as I mentioned earlier. Judicature Act number 2 of 1978, except in cases where an injunction is prayed for in a plaint in any action, shall be by petition and shall be accompanied by an affidavit of the applicant or some other person having knowledge of the facts, containing a statement of facts on which an application is based. So you can see, ladies and gentlemen, the application for an interim injunction can be made in two instances. If if it is a new action, you have to make the application for the injunction in the prior to the plaint itself. Of course, the requirement is an affidavit. And if it is a pending action, it is very important to know. This is where sometimes we make a lot of mistakes. Sometimes we have seen, since you don't have a proper understanding of the provisions of section 662 of the Civil Procedure Code, when you file a new action, you file the plaint, you file a petition, and you file an affidavit as well. So is it necessary to do that? In my opinion, if you really analyze the provisions of section 662 of the Civil Procedure Code, and there is no necessity for you to file a separate petition, if it is a new case, and what is required is a prayer in the relief in the prior to the plaint, that is related to injunction and an enjoining order. Of course, the averment has to be substantiated by way of an affidavit. Of course, it's a pending case, you must have a petition, and that the averments in the petition must be supported by way of an affidavit. Of course, it's either the applicant or a person who's having a knowledge with regard to the facts in issue. So now it is clear how the application could be made in terms of the Civil Procedure Code. If it is an action or a new action, you make the relief in the prior to the plaint. Of course, that prayer has to be supported by an affidavit. If it is a new pending action, you file a separate petition and affidavit seeking the interim relief. That is the procedure that is recognized by law. So if one can argue, so in the event if addition to, if it is a new action, if a separate application is made along with the new action, the petition is filed, what would be the repercussion? What would happen? Can someone take up the position that the application is misconceived? I would say, but of course that depends on as to how the averments in the affidavit is pleaded, without referring to any, without making any reference to the averments in the plaint, and if the affidavit has just been supported or rather accompanied with the petition, I would say one can safely argue the application is bad in law, and therefore that application cannot be maintained relating to injunction. So therefore, just be very careful. If it is a new action, you file only the plaint and the affidavit, and if it is a pending case, you file an affidavit, sorry, a petition accompanied by an affidavit. That will be the application. That is the procedure that is recognized in terms of section 662 of the Civil Procedure Code. So, ladies and gentlemen, apart from that, then the other important matter that has to be borne in mind is the provisions of section 663 of the Civil Procedure Code that sets out the contempt procedures related to injunctions. And it is the trite law that the injunction or an enjoining order issued by court has to be duly respected and complied with. The disobedience, the procedure itself has recognized, it amounts to a contempt of court. Therefore, a person can be charged and punished for contempt of court in case if they violate the terms of the injunction. And thereafter, the other important section, the provisions in the procedural wise, it sets out or rather recognized in section 664 of the Civil Procedure Code, and that has to be well respected and well complied with. If not, and you may come across many difficulties to sustain the enjoining order or to maintain the enjoining order or to get the enjoining order extended from time to time. As I mentioned earlier, the enjoining orders are issued for a period of 14 days. It can be extended for another period of 14 days in case if there are no any objection from the other party. And then the important aspect that has to be looked into in this applications, ladies and gentlemen, no court will grant an injunction right up front. So without the other party being heard. So in other words, in terms of section 664(1) of the Civil Procedure Code, the notice of the injunction must be given to the other party before the same is being issued. So and that will coupled with another important legal the requirement, because every person is entitled to be heard before a permanent order being made against that person. Of course, in practice, we say the principle of audi altram partem. So that is the principle that is indirectly or rather directly recognized under the provisions of section 664(1) of the Civil Procedure Code. So no injunction will be issued right up front without the other party being heard. So so then as I mentioned earlier on in at the commencement of my the presentation, I said if until the injunction is issued, the court are vested with jurisdiction or the power, they have the inherent power or other discretionary power to grant an enjoining order. That is the provision that is recognized in section 664(2) of the Civil Procedure Code. So injunction, to grant an injunction, normally the court, I'm looking at the practical aspect rather than going through, okay, as I mentioned earlier, the main legal matters. Until normally the injunction is granted after giving an opportunity for the opposite party of being heard, and they will file their statement of objections. When the objections are tendered, we are aware that that is the practice in court, and normally there is an inquiry. Inquiry is, of course, disposed of by way of written submissions, that of course based on the application of parties. And in this instance, I must deviate slightly from one little important matter. We are aware when it comes to injunctions, whether you are entitled to lead oral evidence. That is, since of late, a matter that has been debated in many courts, because some have made an application to lead evidence, but of course without the consent of parties, and the consent of your opponent, you are not entitled to lead oral evidence to substantiate your application for the interim injunction. That is the principle that is laid down in the Felix Dias Bandaranayake case, which we will discuss in a short while. So you are not entitled to lead oral evidence, of course, without the consent of your opponent, and therefore that the application for the injunction will be determined based on the evidence that you adduce by an affidavit and the annexures at the time of filing of the case. So that is important, and that deals with another aspect which we will when we discuss some case laws we will come across this situation, because that you must disclose all the material facts and documents at the time the application for interim injunction is made. So, ladies and gentlemen, as I said, the interim injunction will be granted after an inquiry. So, inquiry takes time because there are certain procedural steps that are to be taken. That the defendant must file objections, then they will file written submissions, and the court has to make an order. That it takes time. So till then, can you wait? The injunctions are relief. Of course, we always the discretionary remedies we say. With there's an urgency. If someone is trying to erect a building right across your land, or someone is trying to obstruct your the roadway, that kind of a special circumstances or a special reasons, you go to court to obtain an interim injunction. And can you wait? Therefore, that inquiry is concluded. No, you can't, because you run to court because of the urgency. Therefore, the procedure empowers court under section 664(2) to grant an enjoining order, of course, subject to certain conditions. So, if I may, for the purpose of completion of my the presentation, I take the opportunity to read section 664(2) of the Civil Procedure Code, which reads thus: where it appears to court that the object of granting an injunction would be defeated by delay. Remember, that's very important. Where it appears to court that the object of granting an injunction would be defeated by delay. Now, of course, this is one aspect you must always remember. When you're supporting your application for the enjoining order, you must always endeavor to satisfy court that if the enjoining order is not granted, if there's any delay, if then your rights will be affected. That's very important to know. And it may, until the hearing and the decision of the application for an injunction, enjoin the defendant for a period not exceeding 14 days in the first instance. Now you can see the main requirement you must satisfy court if the enjoining order is not granted, and if until the final hearing and the decision of the application of this thing, that that will have some impact of your application for the interim injunction. If that can be satisfied, court can enjoin him. Court can issue the enjoining order restraining that person from committing any civil act. Then this is the other important thing, the defendant for a period not exceeding 14 days in the first instance. So in the first instance, the court will issue the enjoining order, which is validated for a period of 14 days. Then that has to be served on the defendant. Then the defendant is entitled to be heard with regard to the extension. Now, this is the second limb of section 664(2), which it says, and the court may, for good and sufficient reasons, which shall be recorded, extend for periods not exceeding 14 days at a time the operation of such order. So the second limb, you remember, there is no automatic extension of the enjoining order. With regard to the extension, of course, practically in the day-to-day practice, you hardly see that the court is recording the sufficient reasons for the extension. But of course, section 664 has mandated the word that has been recorded. It is imperative for the court. It says, which shall be recorded extend for periods not exceeding 14 days at a time. So enjoining order can be extended for one time for a period of 14 days, and even for the extension, the court must record the reasons, the good and sufficient reasons for the extension. Why I'm extending the enjoining order? The court must, basically record it. But of course, it has to be normally. In the past, we have seen then the first day, that is the returnable day, when the defendant appears in court or opposite party is present in court, you re-support the enjoining order, the application, to get the enjoining order already in operation extended. And there, the applicants must adduce good and sufficient reasons as to why, to satisfy court, as to why the enjoining order should be extended for a further period. Now, practically what happens is when they come with the consent of party, that's why always quote obtain or rather record of consent of parties, the enjoining order is extended for a period more than 2 weeks. So that is important. That is why to get over or rather circumvent some of the provisions of section 664(2) of the Civil Procedure Code, always judges, they tend to get the consent of parties to extend the enjoining order more than a period of 2 weeks. So other important thing, ladies and gentlemen, this is the other matter which I just want to add little emphasis prior to deal with some of the important cases, which has, basically those principles are the principles based on which the injunctions are granted. That is section 664(3) of the Civil Procedure Code. If I may read that section also for the purpose of completion of the presentation, this is what it says. The court may, of its own motion, or an application made by any party, suspend the operation of an enjoining order issued under subsection 2 if it is satisfied such order was obtained by suppression or misrepresentation of any material facts. That's extremely important. This is where most of us gets into difficulty, because since injunctions, those papers are drafted in a hurry, since there is an urgency, so therefore you tend to lose sight of certain important or material documents, or sometimes you are not in possession of some of the important documents. Therefore, you have to make sure that you have a specific pleading or in the plaint or your petition itself. There you must specifically bring into the attention of court that there is this document, there was this fact, but you are unable to produce to court due to some reason, and you must obtain, at least to get over, circumvent these legal repercussions, and then seek permission of court to tender those documents later prior to any further orders being made. Otherwise, if the document is material or the fact is material, if that document or the fact has not been brought to the notice of court, then it's your enjoining order is liable to be suspended or set aside in terms of section 664(3) of the Civil Procedure Code. Because, ladies and gentlemen, this it is well accepted law, and these injunctions are discretionary remedies. Court has the discretion either to grant or to refuse the application for interim relief. Therefore, that the law requires that you produce all the material documents and facts to court at the time the application for interim relief is made. Therefore, that the authority says you enter into a contract with court. We say that the uberima fides, that cannot be flouted. You must act in good faith. That cannot be the breached. The moment you are found guilty for the non-disclosure or the misrepresentation of material facts and documents, then, ladies and gentlemen, your application to the maintenance of application for interim relief, of course, gets more bleak, and the court will not be hesitant to vacate that kind of orders if acting under the provisions of section 664(3) of the Civil Procedure Code, because the contract, the trust between the party and court is breached, and therefore it cannot be sustained. So, ladies and gentlemen, in this context, we have to pay attention to some of the important cases in the field of injunctions. That is one of the most celebrated cases, if I may draw your attention, is the Felix Das Bandaranayake case. Felix Das Bandaranayake versus State Film Corporation. That is 1981, 2SLR, page 287, which sets out the criterion that will be taken into consideration when an application for interim injunction is considered by court. So in this context, it's a very, as I said, this is the most celebrated case in the field of injunctions, where these several, the criterion, the test have been introduced to our legal system. Firstly, the court has to be satisfied, or court has to be satisfied to see whether the plaintiff has made out what is called a prima facie case. What do you mean by a prima facie case? We'll discuss in a short while. Then the balance of convenience. What do you mean by a balance of convenience? And importantly, as I mentioned earlier, this has a direct connection to section 664(3) of the Civil Procedure Code, the conduct of parties. The conduct of parties. Underneath, court will take into consideration the delay, or the inordinate delay, if I may say the other legal jargon, we say the lashes, then the breach of the suppression of misrepresentation of material facts and documents, then failure to come with clean hands to court, the lack of umarima fides, and those are matters that will be taken into consideration in terms of the principle enunciated in the case of Felix Das Bandaranayake versus State Film Corporation, that the celebrated judgment. Now, ladies and gentlemen, what do you mean by a prima facie case, or rather prima facie case? Prima facie case, if you go through the relevant judgments, where the court has held over and over again over a period of time, especially in the appellate courts, by looking at the documents produced by the applicant, whether he has at least a chance of winning the case, whether there's a probability that he is entitled for the substantive relief at the conclusion of the eventual trial. So remember, when you are a practitioner, when you make an application to obtain an interim injunction, that you have a heavy burden and you have a duty, firstly, not to suppress any material facts or documents, because the law says if you suppress a material fact or a document without going into the merits of your case, whether you have a good case, the court will not be hesitant to vacate or rather refuse the application for interim relief, because you have breached your duty to disclose all the facts to court. So therefore, our bounden duty in the first place as practitioners, when we advise our clients, to disclose all material facts and documents. Then as I mentioned, when you say the prima facie case, you must, by doing that, you must establish, or rather you must satisfy court that at the end of the trial, you are well entitled to obtain the substantive relief. So earlier I mentioned, without substantive relief, only to obtain interim orders, you cannot file actions. So there has to be an application, or rather relief, or substantive relief, that has to be prayed for in the prayer to the plain. So when your application for interim injunction, primarily the court will consider whether you are guilty of suppression or the misrepresentation of material facts, because each and everything is not material. That has to be the document or a fact got to be material vis-a-vis your cause of action. The cause of action, if the suppression or the misrepresentation has given a different complexion by suppressing the document, if the applicant has given a different complexion to the case, then certainly that is a material fact. So that is the test that will be taken into consideration by court, whether that document or a fact has given, had the applicant disclose these matters properly, whether the opinion of court would have been changed. That is important to basically take into consideration. That is how you do the test, whether it is material or not. It gives a different complexion to the case. So therefore, firstly, when you get over the hurdle of that matter, the court will take into consideration whether you have a prima facie case. So always remember, if you are for a defendant, if you are defending or challenging an application for interim injunction or enjoining order, first look into this aspect just to see whether the plaintiff has come to court with clean hands, whether he has submitted or rather produced all the material facts and documents. Even if he has produced all the facts, whether he has tried to twist or give a different complexion to the facts. And by doing that, whether he has tried to give a different complexion to the case, what has been presented. If you can successfully identify that fact, then certainly, without inviting the court to go into the main merits, or rather the question of prima facie case, on the ground alone, on the ground of suppression alone, that you are entitled to have the application, or rather you may be able to successfully defend the application for an interim injunction. So ladies and gentlemen, as I mentioned, that is the prima facie case. Then the balance of convenience that will be taken into consideration by court. What do you mean by a balance of convenience? Now there are two parties. If the interim injunction is refused, what would be the damage for the plaintiff? If it is granted, what would be the damage to the defendant? So when the court analyze, or rather look into the principle related to the balance of convenience, court will take into consideration, in the event the injunction is granted, whether the damage that would be suffered by the plaintiff is more than the defendant, or vice versa. In that situation, if the damage, if the injunction is not granted, would the damage suffered by the plaintiff is much higher than the damage the defendant would suffer if the event if it is refused, then of course the court will come into the conclusion that the plaintiff is entitled for the interim relief, or rather the applicant. So that is the second test. Then the third test we have discussed many times, that is the conduct of parties, the suppression, misrepresentation, failure to come with clean hands. But of course, suppression and failure to come with clean hands goes in hand, and therefore it is your bounden duty to come to courts with clean hands, where all material facts and documents must be disclosed to court without making a severe making a single mistake. So therefore, this case, that is the Felix Dias Bandaranaike versus State Film Corporation, as I mentioned earlier, it sets out this solemn contract and identified, recognized, and if that is violated, certainly, ladies and gentlemen, your application for the interim injunction may not be successful at the conclusion. So vis-a-vis the the prima facie case, as I mentioned earlier, there are several important judgments that one must look into. That is Abhayavardhana versus Abhayavardhana, 1993, 1 SLR page 272. That is 1993, 1 SLR page 272. Then Ranjan versus Selasamy. That is also a very important matter, which deal with the question of prima facie case. That is 1994, 2 SLR page 372. And then Ghulam Hussain versus Cohen, and 1995, 2 SLR page 365. And these cases, these are very important cases that one must read and brush up your knowledge in case if you are in a civil practice and if you are interested in this very important area of injunctions, because that's deal with as to how the law has evolved from time to time vis-a-vis the prima facie case. And And secondly, that is also another important matter that I would like to draw your attention to the principle enunciated in the Hyderabad Industries case that is reported in 1995, 2 SLR page 304, where the law has evolved in a different direction. But in case if you have, if the loss and damage can be quantified, or the damages are an adequate remedy, and it is settled law that you can't, you are not entitled to obtain interim relief. Therefore, you have to be very careful when you couch your words in the plaint or a petition when you make an application for interim order, because you have to, with the supportive documents, you must satisfy court that if the interim injunction is not granted, that you will suffer what is called irreparable loss and damage. Irreparable loss and damage will be caused. And further, you must say, if it is not granted, even if the judgment is granted at the conclusion of the eventual trial, that the judgment will be ineffectual, because there will be no purpose of getting the judgment in your favor in the, and that your rights will be severely affected. So therefore, that when, especially all the practitioners must be very careful when you are drafting your papers, that these requirements or other principles enunciated in this case are properly complied with. If not, one can simply take up the position that there is non-compliance. It is based on that, and several objections could be taken up, because when it comes to injunction, even judges are very careful. Judges will pay little more additional attention to the application and they will evaluate, though they are not bound to evaluate uh, the final merits of the case. They will look at the strength and the weaknesses of the case on the face of the documents, and make a finding. Therefore, that you have to be extremely careful when you make an application of interim order, just to comply with this, the basic legal principles. And I mentioned earlier, whether you are entitled to make an application for only to obtain interim orders, that there is a very important case, Mallika de Silva case, which is reported in 1999, 1 SLR page 85, which says that injunction cannot be sought without having an application or other relief to obtain substantive relief. So therefore, independent, if there are no independent substantive relief prayed for in a plane, that you cannot make an application to obtain interim relief. And ladies and gentlemen, I have come across one little experience in a case where the application enjoining order had been granted by court, but when we looked at the main the case record, we found the case has been initiated only by way of a petition and affidavit. That is perhaps by an oversight in terms of section, as I mentioned earlier, 664(2). If it's a pending case, you are entitled to file a petition and affidavit. Otherwise, you can't. You are not entitled to institute an action or a regular action by way of a petition. Therefore, be careful, and this is very important, that if you have not filed a claim, you can't initiate an action by way of a petition. It is on that basis the whole action was dismissed. So these are little practical aspects that you have to bear in mind. So in that is, I just ran through some of the important or rather salient points, or rather the provisions relating to the granting of interim injunctions, and I have been requested to add little more emphasis relating to Parate execution. Ladies and gentlemen, we are aware the Parate execution rights prior to the year 1990 was vested with certain state banks. That is, especially if you take it, the People's Bank as well as the Bank of Ceylon. So the act itself has conferred this special jurisdiction to these banks to execute parate and parate rights and to acquire properties or to sell properties in at auctions, public auction sales. And in view of certain difficulties faced by the financial institutions to recover their monies in early 90s, latter part of 1980s and early part of 1990s, two acts were introduced. The one is Act number 4 of 1990, that is the Recovery of Loans by Banks Special Provisions Act, and the other act was the Debt Recovery Law, that is 2 of 1990, as amended. That's in terms of the Act number 4 of 1990, several private banks too were conferred with the jurisdiction to execute parate rights and to acquire or rather auction the mortgage properties to recover their outstanding debts in a speedy manner. Now, one of the, because since we are running out of time, I will quickly concentrate on one specific matter, ladies and gentlemen. We are aware that there are if you look at the People's Bank Act, that the provisions of Section 29D, as well as the Bank of Ceylon Act, that has there is a specific provision to say that the resolution adopted by the bank cannot be challenged, and therefore based on that, and I recently at a discussion, this question was posed to me as well by one of our own members, where he questioned me, isn't there any possibility for a party or an aggrieved party to go before an original court and to seek interim orders preventing the bank from enforcing or rather acting upon the resolution? So my simple answer is you can. But of course, that, as I mentioned earlier, you've got to be very careful when you couch your words in your pleadings. Pleadings are the most important matters. But if you look at, for instance, the People's Bank Act, Section 29D, read together with Section 22 of the Interpretation Ordinance, that has clearly removed the intervention of court vis-a-vis the resolution. So therefore, these are statutory rights that are being performed by the bank, vested in the bank in terms of the statute. Therefore, that act, that is a decision taken to parate execute a property, cannot be challenged. But normally, the banks are like this type of the situations. In case if they come across, they rely on a principle enunciated in two cases, if I may draw your attention. That is the People's Bank versus Havasam, reported in 2000, 2 SLR page 30. Another, the important case is Bank of Ceylon versus Lila de Silva, 2003, 3 SLR, page 302. And these two cases, they are the lordships of the appellate courts have clearly held that they are not, the parties not challenged, not entitled to challenge the resolution adopted by the bank in an action in the district court or the original court. It has removed the jurisdiction. But on the contrary, there is another view that has been expressed in the appellate court, when we all are aware that if there are any facts in disputes, if there are factual matters in dispute, that matters cannot be adjudicated or decided in an action in the writ court or appellate court, because you can't lead evidence when the parties are at variance with regard to factual matters. Then the evidence must be led, and by leading evidence, that issue must be resolved. So in that context, and that is the judgment reported in 2005 1 SLR page 94, 2005 1 SLR page 94, where the lordships of the appellate courts have held, when factual matters are in dispute, no writ jurisdiction will lie. So therefore, that now this is how that you must always try to differentiate your facts and circumstances. If in case if you want to go with the district court, you must circumvent some of these legal provisions and rely and bring your course of action within the parameter of factual positions, and then you are entitled to seek interim relief. Certainly, you are well entitled to do that. And thirdly, we have seen sometimes when the property is put for sale, uh, the your clients, they come and meet you, like, of course, perhaps 24 hours prior to the date of the auction sale. You are in a hurry to do the drafts or the rather plain, and then to run before court. And mind you, ladies and gentlemen, you have to be extremely careful if you want to successfully make an application to obtain an enjoining order or an injunction to restrain a bank from uh, committing or rather complying with some of the statutory powers what have been vested. You have to be extremely cautious in producing certain documents. But if you look at the Act number 4 of 1990, there are statutory requirements. Firstly, you must adopt the resolution. You have to notify the resolution to your defaulter or rather your customer. The bank is bound to do that. And then the resolution has to be published, that the notice of the publication must be given, and thereafter notice of auction sale has to be published, and 14 days prior to the date of the auction sale, that the notice must be given to the party, and it has to be posted on the land as well as near the land which is sought to be auctioned. So these are sorry, statutory requirements that has to be duly complied with, because there's a reason for that. These steps have been statutorily recognized. Why? The legislature has expected the bank to get the maximum possible price for the property that is sought to be auctioned. And mind you, and here is a case where the board of directors, without the intervention of court, they are exercising certain quasi judicial powers. So in that context, in my opinion, the compliance of the financial institution regarding the provisions in this act is extremely necessary, and it is imperative. In the event if there is any violation, certainly the party is well entitled to run before court and to seek some interim orders or other interim injunction. But to prove it, now, for instance, we are aware, now since of late we have seen some of the institution, because the law says you have to publish the notices 14 days prior to the date of sale. But we have seen, I have come across certain instances where the bank has put up the banner on the day of the sale, and they have pasted the posters on the day of the sale. They have taken photographs and kept it, and they have proceeded with the auction sales. And in that circumstance, if you can adduce evidence, to satisfy court that there is a blatant violation of the statutory requirements, certainly you are well entitled to get an enjoining order restraining the bank from proceeding with the auction sale. Then, ladies and gentlemen, there is another important issue is, even if you stop the auction sale, because of the non-compliance of certain the steps set out in the act, and there is no impediment for the bank to once again publish the notices and to set for the auction sale for a further date. In that event, unless and until that you have clear evidence show that because of certain issue, the resolution is ex facie bad, then certainly you are entitled to get an enjoining order, later on an interim injunction. So with that, I will wind up with regard to my presentation. And in case if you have any further questions, I'm more than happy to share my thoughts on your matters.
Yeah, thank you, Mr. Nawaratna, for the very informative and a detailed lecture or rather discussion on the issues pertaining to enjoining orders, and you have made a considerable overview with regard to the Parate execution as well. There are few questions that has been posted. May I just put one question?
Yes, please. Yeah.
There's a question asking what is the difference between section 664.3 and 666? Is there a difference, or if there is,
No.
what?
No,
664.3
Yeah.
and 666.
Yeah, there's a slight difference. If you look at the section 664.3, Mr. Galhin, if I may read it, that is, this is what it says. The court may, of its own motion, or on an application made by any party, suspend the operation of an enjoining order issued under subsection 2 if it is satisfied that such order was obtained by suppression or misrepresentation of any material facts. So, in terms of section 664.3, the court is vested with power without any application of party on its own motion or based on an application of party to suspend an enjoining order. Of course, subject to one condition: if that party is found guilty for suppression or misrepresentation of material facts. If you look at section 6, the provisions of section 666 of the Civil Procedure Code, this is what it says. An order for an injunction or an enjoining order made under this chapter may be discharged or varied or set aside by court on an application made thereto by any party dissatisfied with such order. Now, if you draw parallel between these two sections, section 664.3 directly deals with one specific category of application. That is, if you are suppressed any material facts or a document, the section what you have to come under is section 664.3. But if a person is dissatisfied with an enjoining order, now this is the point of argument. Here it says by any party. It necessarily mean, it does not mean that the parties to the case. If you look at section 666, it says an order for an injunction or enjoining order made by this chapter may be discharged. Even an injunction can be discharged, or the enjoining order can be discharged or varied or set aside by court on an application made by any party dissatisfied with such order. So I would say this has given a wider the discussion. It's an open section where any party who is dissatisfied, that any person other than the parties to the case even make an application, and to see whether they can have the enjoining orders or the injunctions varied or set aside under section 666. Because it is not limited to suppression or misrepresentation of material facts as recognized in section 664.3.
Yeah. Another question, Ms. Nawaratna, that if the plaintiff has obtained an enjoining order by suppressing material facts or presenting incorrect facts to court, and by that enjoining order, if the defendant has suffered any loss, financial or otherwise, is there a procedure or is there a provision to ask for compensation without waiting for the end of the case? Is it at the end of the interim injunction inquiry, can the court grant compensation for the party who sustained the loss?
I think Mr. Galhen, the procedure is very clear. If you look at section 667 of the Civil Procedure Code is the answer. If this is what it says: if it appears to the court that the injunction or the enjoining order was applied for an insufficient grounds, what you have to satisfy, whether suppressing material facts or documents or misstating facts or on any other ground or insufficient grounds, or if after the interim injunction or the enjoining order which it has granted, the action is dismissed or the injunction judgment is given against the applicant by default or otherwise, that it appears to court that there was no probable ground for applying for the injunction or enjoining order, the court may, on the application of the party against whom the injunction or enjoining order is issued, award against the party obtaining the same in its decree. Remember, in its decree, what the court grant at the while whether granting injunction or rather dismissing injunction is the cost, not the compensation. compensation is granted in terms of section 667 in the decree, provided the party dissatisfied with that injunction or the enjoining order satisfy court that the harm has caused or a loss has caused to him, and there is a judgment that is the Pires versus Pires. I think it's a very old judgment that is under section 667, where it says, in awarding damage in a case where a party obtains an injunction on insufficient grounds, court should ascertain the real damage suffered by the other party. You can't just because an injunction or the enjoining order has been granted, you can't just merely because it's granted, it's not you don't become entitled to claim damages, but you must adduce evidence to show that you have real damages. Then you are entitled to claim damages in terms, or rather compensation in terms of section 667 of the Civil Procedure Code.
Yeah. Now, Ms. Nawaratna, according to section 667, the party who alleged to suffer any loss can claim for compensation.
Correct.
Does the how the application should be made? Is it on with the objections or separately after the interim injunction is decided?
No, that's why that mainly the damages, the compensation, it has to be decreed by dismissing the application. It goes without saying the decree will not be entered whilst dismissing the application for the enjoining order. That is at the end of the case. So when you are making your claim, of course, when you file your answer, practically what we do is you make a claim in reconvention to say on insufficient ground an enjoining order has been granted, or insufficient ground the interim injunction has been obtained, therefore that you have suffered loss and damage, therefore you are entitled for compensation. So that is the proper way of making an application. On the objections will get negated, or it will go out of the process the no sooner the application for the interim injunction is determined, and thereafter the case will proceed to trial based on the answer plain and the answer. Therefore, it is always advisable to make the claim by way of a claim in reconvention and to basically adduce sufficient evidence to satisfy court that you have suffered an actual damage.
Mr. Nawaratna, there's one last question with regard to the provisions set out in the Civil Procedure Code. Is there any difference that is applicable except the monetary limitations, the procedure adopted in the district court and the commercial high court? Except the monetary value, is there any difference in the procedure?
No, there is no. That is, as far as the procedure, substantive law is concerned, as I mentioned, the section 54 confers jurisdiction on the high courts, district courts, and the family court to grant injunctions. Vis-a-vis the procedure, what is applicable, especially I think you must be referring to the commercial high in operation within the western province. To other provinces, they do not have it, or rather it has not yet been established. So therefore the procedure what is applicable vis-a-vis the granting of interim injunctions, or rather the relating to interim orders is the Civil Procedure Code. Therefore the district court and the commercial high courts, there is no any difference. That's the procedure that is to be followed.
Mr. Nawaratna, I think we have come to the time limitation is now we have almost reached the time limit provided, and I think you have covered all aspects, all important aspects within a very short period, which will be important for a practitioner or a student or even a instructing attorney to know basics about this area of law. And you have also referred to some case law, which are the landmark judgments that will be referred day in and day out in courts when interim injunctions and enjoining orders are concerned. And this makes the end of our webinar 6 in the series of webinars conducted by the Colombo Law Society. It's a privilege to have Mr. Nawaratna, who has been our one of our past presidents and a good friend of the Colombo Law Society, who has been with us. And I think the choice of the president to select him, inviting him, he has justified fully by being a very informative lecture on the topic of his choice. And I would again thank Mr. Nawaratna amidst of his busy schedule, especially being a Friday evening or afternoon, the time after long heavy week. You have given very voluntarily you have come forward for with the Colombo Law Society to do this lecture. And I would like to thank all the participants who joined with us today. And I invite you all to join with us next Friday as well. So we will be having this series for some more weeks and expanding our area of discussion. And with that, I will conclude today's lecture. I think the president is not available at this moment. So on behalf of the Colombo Law Society, I thank Ms. Nawaratna and all who present today. Especially, I would mention the commitment and the contribution made by Mr. Imas Simithias, our program coordinator, who has been busy with his work but has been always very active. And thank you very much, Imas, for your work. And while thanking Ms. Nawaratna again and again, I would wish a very pleasant evening and a happy weekend. Thank you very much. And
thank you, Chatura. It is indeed my great pleasure to be on your panel. And the Colombo Law Society is one place which has given me immense support for the development of my career as well. So I owe it a lot. And therefore, once again, I thank the president, his vibrant EXCO members, as well as the committee for electing me as one of the best panelists and to share some thoughts on the area of my practice. And thank you, Chatura. Thank you very much.